My name is Samantha Movasagi Gonzalez, and I'm an immigration attorney in Miramar, Florida. I've been practicing immigration law for over 17 years, and I'm here to explain the Schedule A green card based process for nurses. What is the nurse employment based Schedule A process? The Department of Labor designates job shortages in the United States under the list of occupations of the Schedule A worker. So what this means is that there are two positions right now that the Department of Labor has designated. One is nurses and the other is physical therapists. Why is this so important? Because as a designated job shortage Schedule A occupation, you're able to skip the labor certification process with the Department of Labor. The labor certification process with the Department of Labor can last 9 to 15 months minimum. And as a Schedule A employee, you are allowed to bypass that process and go directly to the employment-based immigrant petition. It's important to understand that Schedule A nurses are classified under the employment-based third preference. This means when you look at the visa bulletin category chart, it falls under that category list. So the Department of State issues so many visas per category every year, and the Schedule A nurses fall under the third preference-based category. So depending on how many visas are issued is depending on what is the date of the application that the Department of State is working on to issue the visa. This is all designated by the date that the actual I-140 petition of immigrant worker is filed with USCIS. That date is called your priority date, and your entire application process is followed through that designated priority date. So how do you qualify to be a Schedule A nurse? Well, first and foremost, you must have either a full and unrestricted license to practice in the intended state, or must have passed the Commission on Graduate of Foreign Nursing School, the CGFNS examination. When you have these two qualifications and you have a sponsor like a hospital or a clinic that's willing and able to sponsor you, the process goes very smooth from that point forward. Even though you don't have to file a labor certification with the Department of Labor, the employer still has to file what's called a prevailing wage determination. Basically, it's a document that gets filed with Washington, D.C. with the employer's information and the information for the position and the job duties and the location of the position. This now in turn allows the Department of Labor to issue what's called the minimum wage salary for the position. So let's say, for example, you're a nurse and you want to work at a hospital and they do the prevailing wage determination and it comes back that your starting salary is going to be about $50,000. So from there on forward, the employer is now committed to paying you that minimum salary of at least $50,000. The employer also has to post the job notice in their designated area of employment, and once that term period is completed, they can go ahead and complete the Department of Labor ETA 9089. That form, along with the employer information, along with the applicant's information, proof that they have the license, proof of their degree, or proof that they've passed their examination, is put together in a packet and sent to immigration. The employer is responsible for the fees associated with the I-140 petition because, as we understand it, it is associated with the Department of Labor ETA 9089. And in that document, there are specific regulations mandating the employer pay for this part of the process. The filing fees for the I-140 is $555. And if you choose to get a decision on this petition within 15 business days, you can pay premium processing, which is $1,440. Now, once the petition goes through and you get the decision and it's approved, one of two things is going to happen. Either you're going to be in the United States under a lawful status, and you're going to be able to adjust the status because the priority date is current, or you're going to be outside the United States and the petition is going to be transferred to the National Visa Center, where it begins the process for what's called consular processing. Both of these processes are two completely different processes, but they end up with the same result, and that's you getting your permanent residency through Schedule A employment-based petitioning. And really, it's also going to come back to what is your priority date. So let's say, for example, that you file August 1st, 2020 as a priority date for the I-140, but the visa bulletin is working on, let's say, January of 2020. Now, your estimated processing time of waiting to get to the priority date of August 1st, 2020 may take anywhere from 6 months to 10 months. It's really unknown because it goes by how many visa numbers are utilized during that month. And it's all based on predictions and statistics, really, until you get to that point where they're working on that priority date in the example that I stated of August 1st, 2020. When they're in that priority date, then you can apply for either the consular processing outside of the United States or the adjustment of status if you are in the United States lawfully. So those are the two different processes once you get past the I-140 approval petition part. As you can imagine, there have been a lot of changes that have been going on with immigration, but the healthcare system part seems to be going strong. My best advice if you choose to go through this process is really to be patient. The processing times are fluctuating a lot and the fees may be changing, and there's just a little bit uncertainty in the logistics of this process. But for right now, it seems to have remained a solid same where they're designated as a Schedule A, and it's really a viable opportunity not only to help yourself in establishing residency in the United States, but also providing a healthcare service and really being a hero in the front line, especially during these crazy times what we're dealing with the medical industry. Immigration is a very fact-specific process. It really deals with the personal, intimate details of your life to make sure that you qualify for a benefit. We really enjoy practicing immigration law and are here to help you. If you have any questions about your case or want to see if you're eligible to obtain an immigration benefit, such as a Schedule A nurse or any other immigration benefit, please, you can give us a call in our various ways of contact. There's our email address, which is saman, S-A-M-A-N, @fl-ilc.com. Our website, www.fl-ilc.com. Our Instagram handle at immigration_attorney_Saman, and our YouTube channel at Florida Immigration Law Counsel. And of course, if you want to call us or send us a WhatsApp message, you can also feel free to do so at 954-240-1669. And lastly, don't forget to like and follow us on Facebook at the Florida Immigration Law Counsel page. Thank you so much for tuning into this video. Like I said, if you have any other questions or concerns, please give us a call and follow us and like us, and we'll be more than happy to help. Thank you.